A case that could rip Indigenous children from their families may have wider implications on tribal sovereignty and the environment. I'm Yoonj Kim, and this is MTV News Need to Know. The Supreme Court will respond to petitions on the landmark Burkine versus Holland next week. This high-stakes case involves a couple in Texas. They claim that the Indian Child Welfare Act, or ICWA, which prioritizes Indigenous communities in the placement of Indigenous children, is racist against white people. Currently, the Burkines are fighting to adopt an Indigenous girl, while the Navajo Nation is working to place her with a family member in the tribe. The couple already adopted her older brother after a similar battle in which ICWA was undermined. The law gives Indigenous governments jurisdiction over child welfare cases involving Indigenous kids. ICWA was passed in 1978 to ensure these children were not torn from their culture, and it aims to place them either with their immediate family, another family in the community, or a family in a different tribe. The importance of ICWA can't be understated, especially now as unmarked graves related to Indigenous assimilation schools are being uncovered across the country. Through the 1800s and up until the 1970s, the U.S. government forcibly removed Indigenous children from their homes and put them into assimilation boarding schools where their culture was literally beaten out of them. Up to 35% of all Indigenous children during this time were removed from their families and homes. And researchers say that an estimated 40,000 children died either in or because of these schools. And Fawn Sharp, president of the National Congress of American Indians, says that ICWA is part of Indigenous Americans' recoveries. It's very important for us to understand and recognize where we as tribal nations in the continuum of our effort to heal. Now more than ever, we need to protect and ensure every child that's born into our communities has a fair shot at not only joining us in advancing our tribal nations, but being part of that healing process, because we all have a role and a part in that. But this case is about much more than custody. Chase Iron Eyes, co-director and lead counsel for the Lakota People's Law Project, fears that striking ICWA down could have devastating legal repercussions for tribal communities' civil rights. Should the legal arguments of these plaintiffs be accepted by the Supreme Court, it becomes open season on everything from Indian gaming revenues to actual tribal designations, governments, and reservations. ICWA is being attacked within district courts in Texas, Louisiana, Ohio, and Indiana, with interests far beyond the well-being of children. These states have very few Indigenous citizens, and though tribal governments oversee only 2% of all land nationwide, they have sovereignty over 1/3 of our country's fossil fuel resources, worth an estimated $1.5 trillion. And striking down ICWA could undercut their sovereignty, which would open access to these natural resources. The plaintiffs in Burkine versus Holland are represented pro bono by Gibson Dunn, a powerful law firm with big oil clients, including the companies behind Dakota Access and Line 3 pipelines. Gibson Dunn is working on this case with an attorney who helped disestablish the Mashpee Wampanoag Reservation under the Trump administration. He is also working pro bono. Even the Texas Attorney General got involved in this case, which is highly unusual. Rebecca Nagel, member of the Cherokee Nation and the investigative reporter who has done the most extensive coverage on the story, explained that Indigenous sovereignty directly threatens big oil's bottom line. What happened at Standing Rock worried the oil industry. One study estimated Indigenous resistance cost the Dakota Access Pipeline $7.5 billion. It also inspired movements against other pipelines. Industry leaders, including lobbying groups that represent Gibson Dunn clients, have talked openly about why these Indigenous-led protests need to be stopped. Right now, the Cherokee Nation of Oklahoma, the Oneida Nation of Wisconsin, the Morongo Band of Mission Indians of California, and the Keno Indian Nation of Washington are petitioning the Supreme Court to keep ICWA intact. And they're encouraging other tribes to join the fight. It is essential because if ICWA is struck down, this could undermine tribal sovereignty. And without tribal sovereignty, Dakota Access would have finished the pipeline at Standing Rock. And Enbridge would have finished the Line 3 pipeline by now on Ojibwe land in Minnesota. That is why protecting Indigenous children also means protecting the land on which we all live. I'm Yoonj Kim, and that's what you need to know.